All right, it is 11 a.m. and as promised, we are going to get going with the second panel. So hopefully my panelists can show up here. And there they are, wonderful. Well, as I mentioned earlier, for those of you who are on, my name is Skip Durocher. I'm a partner in the Minneapolis office of Dorsey and Whitney and co-head of the eDiscovery practice group. We are now going to, after that wonderful presentation we had, and hopefully that helps everyone sleep easier at night, we're now going to turn to a very relevant topic in eDiscovery, which is proportionality. And for this presentation, we've got a terrific panel, and I'm going to introduce them to you now. First, we have the Honorable Hildy Bowbeer, and Judge Bowbeer is a magistrate judge for the District of Minnesota. She was appointed in June 2014. And prior to that appointment, Judge Bowbeer was with 3M, first managing their product liability and mass tort litigation, and then after that, handling their IP litigation worldwide. Prior to that, she was in private practice. Judge Bowbeer is an active participant in the Sedona conference and speaks on IP litigation management, eDiscovery, and ADR. And she is has a JD from the University of Michigan. Our second presenter panelist here is Sarah Stroebel. And Sarah is Senior Vice President and Deputy General Counsel at our wonderful client, U.S. Bank. In that role, Sarah partners with her direct report team to lead the bank's litigation, government investigations and subpoenas, employment law, and financial crimes and political law functions. Prior to joining U.S. Bank, Sarah was with Lindquist and Benham, which is now part of Ballard Spahr. And Sarah received her JD from the University of Wisconsin, Gold Badgers. And finally, we have my colleague, Eric Weissenberger, who's an associate in the trial group at Dorsey here in Minneapolis. Eric represents clients in complex civil litigation and government contracting matters and works with me on a couple of significant matters. And he is a 2016 grad from the University of Minnesota Law School. So let's get started. Next slide, please. So I guess the first question is, does proportionality matter? And if so, why? Well, the answer to that, the first question is, of course, yes, because otherwise we wouldn't be wasting your time here this morning. But to give you a little context, we go back to 2013 when a committee was formed called the Conference of Chief Justices Civil Justice Improvement Committee. And their job was to examine the civil justice system in the U.S. and to develop a comprehensive set of recommendations for civil justice as we were moving into the 21st century. In 2016, that committee came up with a report that was then adopted and implemented. And the report discussed a number of things, including the costs, delays, and uncertainties of litigation. And it concluded, as part of that discussion, that many civil cases needed to be right-sized, and that proportionality was the cornerstone of that right-sizing effort. So with that in mind, I'm going to turn this over for a little bit to Eric, who's going to talk about how proportionality has been addressed in the federal rules and also by the Sedona Conference. Eric, take it away.
Hi, everyone. I'm Eric Weissenberger. As Skip mentioned, I'm an associate in Dorsey's trial group. So although it always hasn't been a priority, proportionality has actually been a part of the federal rules since 1983. However, for many years, it was loosely enforced, if enforced at all, and cases were growing out of control, particularly with respect to discovery issues. As a result, in 2015, as a result of what Skip just mentioned, the conference, the rules were amended to emphasize proportionality. First, Rule 26, as you can see here, was amended to remove the language allowing discovery requests as long as they were reasonably calculated to lead to the discovery of admissible evidence. And this language was too broad. It allowed a requester to seek almost any information, even tangentially related to the case, in the hope that it might lead to a smoking gun. This encouraged, for example, fishing expeditions and other improper means of discovery. And the way to fix that language was to replace it with language that the parties may seek discovery that is relevant to any party's claim or defense, which is stricter. And that was buffered by the 6 proportionality factors listed here, which we'll analyze in detail on the next slide. Next slide, please. And so here we see the new Rule 26b1 showing the scope of discovery. So as I mentioned, this did away with the pre-2015 reasonably calculated to lead to the discovery of admissible evidence language. Nevertheless, you'll still see attorneys object, apparently using their old boilerplate forms from pre-2015, that a request is not reasonably calculated to lead to the discovery of admissible evidence. And this should really be a huge flashing sign that the discovery objection is boilerplate and therefore ineffective, begging for a meet and confer letter, educating opposing counsel on a 6-year-old rule change, a letter that, the opposing counsel won't want to put before the court. This can be effective in discovery disputes. And the language here, the new Rule 26b, particularly the proportionality factors listed in red, is important to break down because it provides several swords and shields for discovery disputes. And I'd like to briefly highlight a few of the factors that aren't quite so self-explanatory. One is the importance of the discovery in resolving the issues at hand. So this is a useful tool for preventing those fishing expeditions and keeping the parties focused on the primary issues in the case. For example, if opposing counsel attempts to go down a rabbit hole of something that seems like a sideshow from the main issue, this language acts as a stricter layer of relevance objections, where the previous rules permitted counsel to go after anything that might lead to admissible evidence. The next portion I want to highlight is actually 2 of the factors here, and it's the amount in controversy and the parties' resources. So these 2 factors are similar to each other and are great changes because they create a shield against an attorney that wants to bury the other side and burden some discovery requests in a way that previously would have been permissible. And this is particularly important in lower dollar value cases, and even in higher dollar value cases can help reduce the risk, although it doesn't eliminate it, of course, of the party's resources shaping the way that the case goes rather than the merits in the claims, which is, of course, a positive change. And the last factor that I'd like to highlight is the last factor here, and that's whether the burden or expense of the proposed discovery outweighs its likely benefit. So this is a useful catch-all. If a party wants to make discovery requests that require the other party to sift through hundreds of thousands of documents taken from numerous custodians and data sources, they better be able to show that it's worthwhile. And as we'll see later on in this presentation, courts are really taking this rule seriously. Next slide, please. Now here we have the committee note explaining the basis for the new rule change. The committee's language here, especially regarding the ongoing development of e-discovery tools and stating what parties should now be willing to consider, indicates that while this is not a perfect solution that made the discovery process flawless overnight, it is a step in the right direction. And an important aspect of this note is that courts and parties need to be willing to consider the opportunities for reducing the burden or expense of discovery as reliable means of searching electronically stored information becomes more available. And this has also come up in recent case law. Courts are enforcing this language and making parties really seriously consider electronic means of reducing costs and burdens, such as, for example, keyword searches and deduplication software. As the committee explains here, as this software continues to develop, it will become crucial to reducing the burdens and expense of the discovery process. Next slide, please. And here we have some changes to other rules related to proportionality. As you can see here, there's accelerated timeframes for understanding the document universe and the volume. And this is done to improve at the start of the case. And as the committee had explained, it's important to get right size and correct early on. So you can see by the shortened time frames here, 90 days after the appearance of a defendant and 120 days after a complaint has been served on a defendant, the parties need to get the schedule, or the parties need to talk to the court about the scheduling order. And 21 days before a scheduling conference is held, the parties need to confer. And these are good changes because they get the parties talking early. And we'll see a little bit later on that this is a change that was pushed even by the Supreme Court itself. So, and this was done really to make sure that the parties understand the scope of the case sooner. And in addition to these, in addition to the rules listed here, Rule 16b was also amended to require the scheduling order to provide for the disclosure, discovery, or preservation of electronically stored information, or ESI. To effectuate this new rule, Rule 26F3 was also amended in parallel to require the parties to discuss ESI at the Rule 26 conference, which, as we've seen, is happening sooner than it was in previous iterations of the rules. And this is, again, an attempt to force the parties to discuss the scope and methods of discovery as soon as possible to help reduce the burden of excessive discovery that comes from parties not understanding the scope of the case early on. Next slide, please. On this slide, which you can read to yourself, and I won't waste your time by reading to you, the Supreme Court discussed the importance of the proportionality rule changes that we just discussed. And these are aimed at reducing the costs of discovery by forcing the parties and the court to talk as soon as possible. As the court explains here, discovery is made less burdensome by discussing it early on with an eye toward right sizing. This is the part here about how a lumberjack saves time when he takes time to sharpen his axe. So the reason that this is so important is that if we consider the alternative, namely waiting until the parties are already in a discovery dispute to force them to analyze the discovery needs of the case, that alternative is ineffective. The parties are going to end up digging in their heels. Attorneys are going to fight. They're going to have an eye on some document that they think they'll be able to find. And the parties just won't come to a common ground as easily. So if we get the parties talking earlier, pre-discovery disputes, the court reasons here, then they can make sure that the discovery disputes there's rules set out for the discovery disputes early on. In short, the court here was hoping to rein in the spiraling costs of discovery and did that by forcing the parties to focus heavily on proportionality as soon as possible. Next slide, please. The Sedona principles, which are discussed here, are e-discovery guidance promulgated by the Sedona Conference, a nonprofit organization. So one goal of the Sedona Conference is to improve the litigation system in the United States. So they've released now 3 versions of the Sedona principles, a best practices guide for e-discovery. One of those principles is encouragement to the courts to apply the new proportionality standards, including the 6 factors that we discussed earlier. Comment 2, shown here, is heavy on proportionality, explaining that parties attempting to follow best practices for e-discovery need to emphasize proportionality and apply it to all aspects of e-discovery. Comment 2C here even states that parties should explicitly discuss proportionality at the Rule 26 conference and with the court at the initial Rule 16 conference. As I'm sure you all know, most people have not yet taken this advice. I know I haven't often actually heard a party or a court suggest discussing proportionality of discovery that early on. At that stage, most attorneys are still trying to wrap their head around the scope of their own documents, much less having a full understanding of what the other side has and what we need. But that's the point of the Sedona Conference emphasizing these principles now. They encourage us to break these old habits and talk about these issues early on because it saves us a lot of work, it saves our clients a lot of money, and those are positive results. And again, we want to avoid having parties wait to have these conversations until they're already in a fight. We want to talk about this when the lawyers are as amicable as possible. This will help set the ground rules for discovery disputes, ideally saving time and money later. And now for the next slide, Skip is going to discuss these amendments.
All right. Thanks, Eric. And you're sort of revealing your youth there when you talk about the fact that lawyers are more amicable at the early stages of the litigation, but keep that optimism, I guess. But thanks for talking about the rules and about the Sedona conference, and discussions on proportionality, because they do suggest a significant sea change, and now is a good time to bring our other panelists into the picture, because that's really who people are here to listen to anyway, or hear from anyway. And so let's start with Judge Bowbeer, and Judge, I'd be interested to hear your thoughts and your observations on whether these amendments and the Sedona guidelines and this notion of the parties getting together early and trying to work things out and involve proportionality, whether you've been observing that on the bench.
I do think it's making a difference, although it would certainly be described better as evolution rather than revolution. As Eric pointed out in one of the earlier slides, some of these old habits and some of the associated boilerplate do die hard. And even among judges, I mean, you can still find orders from judges on discovery that cite the pre-2015 mantras. So we all have had to evolve and develop our approaches. I think one of the things that is key here, and where it happens early, as Eric pointed out, it does make a difference in the litigation, is if the parties first talk to their clients before the 26F conference. And in fact, we, meaning the Federal Practice Committee and the United States District Court here in the District of Minnesota, recently completely revamped our guide for preparing for 26F conferences and put a lot of emphasis on what are the things you ought to be talking with your client about first. Because if you don't have that conversation with your client, it's real hard to have a very thoughtful, informed conversation with the other side, which in turn makes it hard to have a thoughtful, informed conversation with the court. Relatedly, I've been encouraging counsel, the parties, to take advantage of the opportunity offered by Rule 34 to deliver, not serve, but deliver an opening set of document requests to the other side before the Rule 26F conference, so that you've got some grounding, you've got some actual concrete requests in mind to ground that conversation. And where parties and counsel have done that, where they've had that conversation with their clients, have had a grounded conversation with the other side, I do think they're coming better prepared to the Rule 16 scheduling conference and laying a good foundation for the litigation to come.
And that preliminary document request or set of requests, that is designed just to facilitate discussion and is not prompting a response date. Is that correct?
Right. Well, the rule provides that you can deliver it in advance. It is not considered served until after the completion of the 26F conference. But of course, there's nothing that says that you can't include in the 26F conference a conversation about the breadth of the requests, and perhaps as a part of that conversation lead to a more focused set of requests rather than the ones initially drafted. But at least gives you something, oh, that's what you're looking for. Let's talk about how that might work kind of conversation.
And either reveal some agreement perhaps, or if there's a disagreement, an opportunity to bring that up with the court early on.
Indeed, indeed.
Great. Well, let's then see what the in-house perspective is. Sarah, I know, I think you and I served on some sort of committee a while back on e-discovery. So I know you've been connected to e-discovery and working in that area for a while, although your current job, you probably aren't as directly involved, but you've got direct reports who are. So maybe you can share with us the observations you and your team have with respect to the impact of the rules and Sedona conference principles on proportionality.
Sure. Thanks. Yes, mercifully, I'm not as close to discovery as I used to be, but I've talked to the team, and of course I have the chance to observe case trends. And I would say, I agree, it has been an evolution, certainly not a sea change. In terms of how we behave, right? How the rules have affected us, I think it's done so much more on our small to mid-sized cases, right? Where we might tend to get outsized with discovery. And I think we probably had a habit of taking for granted that discovery would be narrow in these cases. And so we didn't need to do as much upfront work. Like, oh, we know where everything is. We see cases like this, and maybe not educate ourselves as much as we really should have, right? In order to comply with the rules and best navigate discovery going forward. And so I think we've gotten much more sophisticated at doing that, learning what the tools are available, engaging our e-discovery team, even on small cases, and sort of getting ourselves ready to have those conversations. Less so on the big cases, right? Those are still big cases with lots of discovery. And we already, I think, probably had our best practices in place. The other thing I'll say is on the other side of the coin, I think it's had some influence on how we deal with plaintiff's counsel. And particularly, again, in these cases that are smaller, this taking a little wind out of the sails in terms of threatening you with expensive discovery to try to extract, right, a settlement that isn't necessarily warranted. So that, that's been another upside of this. It's changed a little bit the behavior by some plaintiffs' counsel.
Yeah, and I agree with that that thought about big cases versus little cases, because it is harder for me to raise the proportionality issue on a big case. And so I think what it's really has been designed to do primarily is to right size discovery in smaller cases. But I guess I'd flip it back to the judge and see if you had any thoughts on that issue, Your Honor. Is that what would you react differently, or how would you react on a proportionality argument in a large case? Are you still willing to consider proportionality, or do you think it kind of falls by the wayside?
Oh, absolutely. And the reason is that as Eric pointed out, the proportionality factors are not just about the size of the case and the resources of the parties. I think one of the key things that the changes in 2015 kind of brought us back to and grounded us in is, what is the incremental value of what's being sought? What's the return on investment, if you will? And how is the importance of what you're looking for in terms of the issues that it relates to, and in terms of the importance of that evidence by comparison with what you've already got? How does that compare with the incremental cost of going out and finding it? And that is a perfectly appropriate consideration. It's a necessary consideration, regardless of the size of the case.
Good. Well, I think I'm certainly pleased to hear that. I suspect that there's others on this conference who are also pleased, because I think while it's more difficult to think about how to apply it in those cases, I agree. The factors that Eric's gone through already do give you the opportunity to raise those arguments. So let's move on then to the next slide and talk about proportionality in practice. Move a little bit from theoretical to real life. So much of this relates to burden and who carries the burden in these arguments about document production and motions to compel. And I think with respect to proportionality, we have both parties that can end up having to carry the burden. If you're looking for discovery, you're going to have the burden of showing why it's needed. And if you're resisting production or resisting a motion to compel, it's going to be your burden to show why not, why you don't have to produce that information. So, Eric, do you want to talk a little bit about how that works in real life?
Thanks, Skip. So this slide shows the ways in which proportionality can help shape discovery. So First, we'll talk about the number of custodians with discoverable and sufficiently relevant information needs to be discussed between the parties. So obviously you can't just search the inbox and phone of every employee in the company, even though there's always that minuscule chance that some unexpected inbox has a smoking gun. But as the number of custodians requested gets more reasonable, the analysis and the balancing test becomes difficult. For example, if a party responding to discovery requests is confident that the vast majority of emails from one engineer on a team would be duplicative of the inbox of another engineer on a team in this example, at what point does proportionality take precedence over potentially relevant information? It's a difficult balancing test and one that can require court intervention. But as discovery technology improves, it can help answer this question. So if you take that same engineering example, discovery tech has made leaps in recent years in deduplication software, meaning that it might not be that costly anymore to find out just how much overlap there is between those two engineers on the same team. And these are the types of the solutions that courts increasingly expect parties to use to handle disputes, as indicated by the Sedona principles and that Supreme Court report that we looked at earlier. Next, data sources. Again, do you really need to search the text messages of an employee that was only tangential to a project? Unless the company heavily used texting for the project at issue, probably not. But again, it's usually not such a simple decision. And this is another balancing test that's causing some heartburn for parties in courts. And finally, what other facts matter to this analysis? Do you need to subpoena a third party to get their data? Will it be reasonable given the needs of the case? That's what the parties need to find out. And next, how does proportionality come up in discovery disputes? It's, as we talked a little bit about boilerplate objections, it's not enough to just throw out a boilerplate objection that a request is unduly burdensome. Instead, the request needs to say that the response needs to say that the request is unduly burdensome because, and include a good reason why. And this is where you can use proportionality. Maybe it's unduly burdensome because the case is worth $50,000, one of those smaller or mid-sized cases that Sarah mentioned. And based on a keyword search conducted to evaluate the scope of the request, there's 2 million pages of potentially responsive documents. This type of explanation encourages the other party to work with you and resolve the dispute without the court, and if court intervention is needed, will help your standing before the court. And the requesting party is also still required to prove relevance. That doesn't go away with the proportionality rules. And this can come up in a proportionality setting because the request might be so broad as to possibly hit relevant documents, but it also hits thousands of other irrelevant documents. Do the needs of the case require the parties to sift through that much data to find information? We'll find out kind of where one court drew the line a little bit further on. And finally, if a party resists discovery on grounds of disproportionality, they'll need to show why it's not proportional. Again, boilerplate objections won't do the trick, and sampling might be required to prove your position. It can be a great help to your argument to the other party and to the court to use effective sampling. If you can show that a search retrieves 2 relevant documents out of every 100, then depending on the size of the request, maybe you can show it's not in line with the needs of the case. And again, we'll see this come up in a case we'll discuss later. But for now, I'll pass it back to Skip for another discussion.
Yeah, thanks there, Eric. So Sarah, let me start with you this time. And from the bank standpoint, what's, Eric's talked about some of these practical approaches, reducing the number of custodians that really have information that's relevant. Which data sources are the most important? How do you call those down? Sampling to demonstrate what's relevant, what's not relevant. Without sharing too many state secrets, can you comment on what the bank's been doing here?
Sure. We've always had a very custodian-focused approach to discovery because we are made up of a lot of people and we are made up of a lot of systems. And there isn't like a magic, much to plaintiff's counsel's chagrin, there isn't like a magic system where we can type in a word and then like everything relevant comes up. So we really do have to be sort of painstaking about identifying custodians and identifying data sources, given the way that we retain information. So I will say, like, we've always been pretty good at that, and we are now even better about doing that early on, really identifying the key custodians. Of course, we start broad. We can get into this later, right? For legal hold purposes, you might have a broader group of custodians, but then we really want to focus on a core group of custodians where we think we're going to get the most relevant information, and same with data sources, right? We often have more than one data source for the exact same information. We need to understand all of those and then ideally just search the one that is most relevant. So I would say yes, I guess that's practical. We are very good about educating ourselves about where the information is and who has it. We have done sampling in some cases, you know, primarily where they want us to run a key search that's like, you know, bank, right? Which is not a very good search, or something really broad where we can demonstrate that it needs to be connected with other search terms in order to pull up information that's more relevant, right? And this is how much you're going to get if we do it the way that you say. I don't know that we've had to resort to that many times. Again, if we can educate people about what we have, where we have, who might have it, it tends to take away the need to do things like sampling to prove your point.
Yeah, and have you observed in the past few years as proportionality has started to take off a bit? Have you been able to observe any different discussion between your counsel and plaintiff's counsel? You know, are plaintiff's counsel willing to accept the reduction of custodians or accept a demonstration of sampling that it's not, you know, you're not triggering the right results? Have you observed any of that?
Yes, I do think that's improved, again, because that's the expectation, right? That everybody take a little bit more of a reasonable approach. So it's not, some of it depends on the jurisdiction, who the judge is, who the plaintiff's counsel is, but I do think we've had luck having more productive conversations early on and not having to go quite as far to prove our point as we might have without these rules.
Right. And Judge, how about from your perspective? Do you see evidence of these practical approaches, you know, when disputes do come your way?
You know, it is all over the map, but yes, you know, among experienced counsel, I am seeing, or actually maybe more importantly, I am not seeing, in other words, the ones who really have these thoughtful, practical conversations are the ones I see less of. So they resolve all number of disputes that I never hear of, bless their hearts. It's the ones who are really less, often the ones who are less knowledgeable, and this is true on both the requesting side and the responding side, the ones who know kind of only enough to be dangerous and don't get advice from someone who's more knowledgeable, where I see more of the issues, the requests not being that specific, the responses being cursory. And what I'm looking for are counsel on both sides who see themselves as problem solvers. Here, if it's a responding party, not just saying that would be too expensive, that's too broad, you know, sort of this arms crossed, you know, no, that's all I'm going to say on the subject. But the ones who say, but here's what we can do. Here's how we can make this manageable. Here's the date range I think is appropriate. Right. And to come up with what in my product liability days I would have referred to as the reasonable alternative design. And the same for the requesting party who's willing to engage and say, well, if that doesn't work, here's what we're really looking for. Let me help you problem solve it. Let's see if we can get at it this way. And the other thing I think people shouldn't forget about is both the ability of technology to make it less expensive and the ability of old school methods to make it less expensive. There's no substitute for sitting down with your custodians for interviews and saying, what do you have? Who else do you think has it? How is it stored? Do you actually have designated files? Maybe I don't need to keyword search because you've got a project file, you know, for Project Bo Diddley or whatever it is. And that could have the lion's share of everything they need. So remembering the old school methods as well as the new tech methods, I think is important here.
No, that's an excellent point. And I do think we sort of now, because we're also enamored with some of these, and frankly, some of them are very helpful, these, artificial intelligence and other technology advances, we forget that there are some ways, as you say, old school, that we can maybe, narrow things down and sharpen our axe before we need to use those things. So. Great. Well, Eric, I'm going to turn it back to you. I think we're going to have you talk a little bit about what's going on with the case law, and then just a word of warning to our other two panelists. We're going to then, ask what their observations are with, what the courts have been doing. So, Eric, you want to spend a couple minutes on that?
Thanks, Skip. So next, we're going to discuss a few issues that have been raised under the new rules, including one recent case that dealt with proportionality issues. So as has long been the case, and still is, the court's primary concern is whether the requests seek relevant information. But that scope is now narrowed by the court considering whether discovery has hit the point of diminishing returns. In other words, are the requests likely to reveal sufficient useful information to be worthwhile, or are they duplicative and covering a lot of the same information? So under the new rules, a request that is likely to find one somewhat helpful piece of information buried under thousands of documents is not likely worthwhile. And so the factors here are the ones that we have already previously discussed. So I'll just, as you take a look at those, I'll briefly discuss a case that implemented one of these factors. So this is MA v. Wyndham Hotels, a case from the Southern District of Ohio in 2020. So in that case, the parties were through the motion to dismiss stage of a Trafficking Victims Protection Act case, a very important issue, hitting the first factor. And the parties disagreed over the scope of backup logs in that case. Defendants wanted to exclude from their ESI preservation obligation data maintained in electronic backup systems, server, system and backup logs, and calendar entries and contacts from mobile devices. Defendants wanted to exclude data that was substantially duplicative of data more accessible elsewhere, whereas plaintiffs wanted that language to read entirely duplicative. The magistrate judge applied principles of proportionality to make a determination in defendants' favor. The Southern District of Ohio, relying heavily on the Sedona principles and emphasizing that its decision was indeed guided by proportionality, adopted the magistrate's decision. As the magistrate noted, plaintiffs would still receive all kinds of relevant data, and any data that was not duplicative would be very limited. The magistrate also noted that defendants' position is spot on with what is going on across the country with respect to proportionality rules. And this decision relied mostly on that catch-all factor. The magistrate and the judge decided here that the juice was just not worth the squeeze. Skip?
Yes, thank you. And as I warned the other panelists, I do want to find out, we talked about what the parties have been doing. The question now, and I'm going to start with Sarah, so we can put the judge on the spot at the end here on this one. What have you had any observations, or your team, direct reports, having any, experience with courts and what they've been doing with proportionality arguments?
Sure. Before I answer that, I have to thank Eric for the Lizzo reference in the juice being worth the squeeze. Bravo. As far as proportionality in the courts, I have to tell you, I surveyed my team, and we have not recently had, a significant discovery dispute in a court where we sort of had an outcome that is worth talking about. I think we've actually had quite a bit of success doing what we're supposed to be doing and keeping it out of the magistrate's hands to decide on our behalf. So of course, we keep an eye on what's happening with case law developments, although it's much less of a big deal than right. There was a period, right, where we were all watching discovery related case law, and you were so scared you were going to get sanctioned because you weren't keeping enough, right? It's not as sort of a threatening environment as it was once before. So admittedly, I'm not the best person to answer this question because we have not found ourselves in a situation where we've needed to rely on the court to resolve it for us.
Well, you're clearly already doing what Judge Bowbeer has suggested you should be doing.
Yes, exactly.
And, you've been avoiding those disputes.
Perfect. Right. We are perfect. Nothing to see here.
Yes, right. And I got to say, I've had the same experience, so I must be doing it right as well. seriously, I have not had in the last few years a proportionality ruling. I've used those arguments with opposing counsel. We've been able to reach some agreements. So I don't think we've had a case where I've really had to push a court, on a proportionality issue. I've talked to some of my colleagues, and several of them have, both in the District of Minnesota and elsewhere. So, Judge, I guess we will turn to you, and perhaps you can tell us what you've been doing, and maybe what you've observed, what your colleagues have been doing with respect to proportionality arguments.
Well, certainly my sense of, we all believe the best of ourselves. My sense of how I've been approaching these cases, and absolutely that of my colleagues, is that we very much, both since 2015 and honestly prior to 2015, because as Eric noted, the concept of proportionality was always there. It just wasn't called out with quite so much emphasis. Kind of consistent with the experience that Sarah reported, I don't get a lot of motions that just boil down to pure proportionality. Some have to do with, is it or isn't it relevant? Just good old-fashioned relevance concerns. Others have to do with issues around delay and that sort of thing. But I've had a few. I encourage as much as possible the parties to come to me either through my informal dispute resolution process, or at least to have a conference call with me before the formal motion gets filed, so that we can explore in a more informal setting that problem solving that has or hasn't happened. And often when it comes to things that do boil down to proportionality, through those informal conversations, I'm able to provide some guidance about, based on what I'm hearing, I'm kind of leaning this way. Feel free to file your motion. I'll read all the briefs, but I'm feeling this, I'm not feeling that. Have you thought about this, or have you tried that? Send them back to me and confer further. And a fair amount of the time, the motion itself never comes, because I've given them a sense of where I hope common sense is leading me, and they take it from there.
Yeah, and I do think when we do searches and getting ready for these CLEs on various topics, I think we haven't found as many proportionality decisions as we might have thought, given the way it has been called out in the last few years. But I think so much of it has to do now with particularly the federal courts implementing these informal conferences and getting the judges sort of leaning one way or the other, and the decision then being made that, well, it's not worth spending the time and money to get that decision made formally rather than informally.
Now, I mentioned that sometimes these motions get decided on other grounds, and I've had more than one case, fortunately not lots of them, but more than one, where I concluded that the responding party had been so boilerplate in its objections that they had essentially waived their right to come back and argue proportionality. Now, I don't go there lightly, but where, despite significant efforts by the requesting party to get to something that would work, the responding party just isn't doing what they're supposed to do, then at some point, I think they waive the right to have me or anybody else dig into proportionality. You've got some obligations when you respond. Similarly, and my scheduling orders reflect this. Similarly, I'm pretty insistent that requests need to be specific as well. So when you've got the everything and a pony request met with the boilerplate response, then I sort of throw up my hands and, what can you do? It's not my job to rewrite either the request or the objection.
And is there a decision out there with your name on it that does make a finding that the proportionality objection has been waived?
There may be one or two. There might be one or two.
All right. All right. Well, thank you both for that. And so, I think what we wanted to do here is spend just a couple of minutes talking about applying proportionality at different stages of the lawsuit. We've already talked about, how the rules and the courts are urging people to deal with proportionality earlier and in hopes of getting discovery disputes resolved. And so, when you look at it, it doesn't get much earlier than the litigation hold, and then, eventually the meet and confer. And so what can you do, even at the litigation hold stage, to start applying proportionality? Well, one thing is to assess your custodians. We've talked about that a little bit, rank their importance. I mean, one of the most effective ways to manage e-discovery and cost is to carefully define the scope, and particularly the custodians. It's just self-evident. The more custodians, the higher the cost is going to be, not just for preservation, but for everything: processing, review, production. Try to narrow down those custodians, but have a defensible position. I know there are some jurisdictions now, I don't know how many, but I know the Eastern District of Texas actually does impose a 5 custodian limit on its IP litigation brought in that jurisdiction. But you do have to be prepared, as we've talked about, to demonstrate why additional custodians would be unduly burdensome, either because their information isn't relevant or because the cost just would exceed the benefit. So anyway, custodians is one way to apply proportionality early on to reduce costs. Understanding the data sources, we've talked about this both in the first session and then earlier today. But some of the low-hanging fruit is easy. Email, e-docs, those are fairly straightforward in collecting, processing, reviewing, producing. But there's other things. Phones. We've talked about phones. I mean, I think it costs like $500 to $700 to image a phone, and so you should be asking those questions that we've talked about in the earlier presentation. Are people using their phones for business? Can you convince the other side or the court that there's just not going to be relevant information in texts, and avoid having to do that processing? Understanding costs associated with preservation. I mean, and part of that is, what's the client's appetite for broad discovery? I've got a lot of times when clients, want to get very broad discovery from the other side, but they've got to understand one of the attendant costs with that is that what comes around goes around, and the more broad that am in my discovery, it's likely going to get a similar response from the other side. So, and then it's hard to argue against it once they've kind of mimicked what I've done. And cooperation, going hand in hand with proportionality, we've talked about that too. Not only should you be having intelligent conversations with your client and its IT department, have those early on conversations with your opposing counsel, and hopefully you can identify disputes early on and try to avoid those. So that's the earliest stage. If you go to the next slide, the next step is collection, processing, and review. Again, I think you got to consider what are the costs to collect. We've talked about reducing custodians, and we talked about, do you really need all the data sources that are out there? And you heard in the earlier presentation, Jabber, Slack, these other sources. You're going to get requests for those, and again, to the extent you can show some sampling to demonstrate that there's little or no relevant information, you're going to be able to hopefully convince the other side, and if necessary, a court, that you don't need to go to each of those data sources. Technology, we talked about that already. The judge, it reminds us to, look to old-fashioned methods, but you also can, when you get to the correct point in the case, use technology. I mean, there's email threading that can reduce vastly the number of emails. Search term analysis can not just use the right search terms, but then it can show you what the hits are and when the hits stop coming, and that gives you a defensible position to stop doing your searches. So use that search term analysis. In the earlier presentation, we heard about continuous active learning. Again, tells you when it's defensible to stop your searching. Machine translation, for foreign translations, there's technology there that can reduce the costs of having to deal with that. Domain analysis, you heard Kate Johnson in the first presentation talk about how domain analysis can help streamline and expedite particularly privilege log reviews. So all sorts of technology that we can use, and don't lose sight of any of that as you're doing your the second stage of collection, processing, and review. So let's go on to the discussion point here. And I guess the question, and I don't know, Judge, if you want to take this on first. I think we probably covered some of this already, but do you get a sense of when the proportionality issues are coming up and the analysis are coming up? At what stages are people? I know, I'll just say, I was involved in the GW, George Washington University proportionality project that's been going on. And we had a big discussion about when do you apply proportionality? How much can you apply at the litigation holding collection stage versus later on? So anyway, from the bench, do you have any sense of that?
I think there's typically less discussion of it with regard to preservation than there ought to be. I think it isn't occurring to parties. Now, decisions are probably being made, but I don't know that I don't know that they're discussing them with each other. As the case goes on, my sense is that parties are increasingly trying to look at what some of the authors have described as that sort of target metaphor, where we're trying to go first for what's going to be the core discovery. And in fact, in some districts, the local rules have actually kind of adopted that concept of core discovery in employment cases, IP cases, that kind of thing. And then looking as a party wants to expand into the outer rings, then starting to look at the proportionality of getting more. So I think they're starting to think about proportionality as a concept that ought to inform discovery throughout the case and isn't just a one and done exercise.
I know from my perspective, and I want to ask Sarah about this too, but from my perspective, I think that's true. I tend to still suggest to clients that they should be overly cautious when preserving data. And I think that part of that is because I'm still not very good about going to opposing counsel right away and having that discussion right away. And so without having that discussion right away, you run all sorts of risks if you don't over preserve. Whereas I think as then you start getting into document requests, then you have to start having conversations with the other side, and maybe you either reach agreement or it comes to a head and we get a blessing from the court of what to do. So that's I'm probably guilty of some of that. But Sarah, how about the bank? What's the tendency applying proportionality and reducing the amount of preservation versus later on?
Yeah, similar experience to you, Skip. I think we still tend to preserve pretty conservatively just for fear, right? You don't want to miss anything. The case might evolve. The parties aren't talking as much, right? Because we issue a legal record hold immediately upon getting a new case, right? And so we haven't even really had a lot of back and forth with opposing counsel at this point. I would say, and it's not particularly burdensome, typically adding more custodians. So in particular, we might add more custodians. When we get into more complex data sources and we have to make decisions, particularly where data sources might be duplicative, right? That might be a place where we decide we're going to lock down or change the retention schedule on one data source, but not on another, if it truly seems that they're duplicative. In an ideal world, right, we would be talking to opposing counsel about that.
Right.
And just being transparent about the choices that are being made if we're going to make choices like that. But you can you can imagine a scenario where you just don't even want to do that, because of course you bring it to opposing counsel and they're going to say, well, you knock it all down, right? And so, sometimes you just lock it all down, or sometimes you make a well-informed choice about what needs to be done and what doesn't need to be done, and not everything needs to be run past opposing counsel at that stage, I think, so long as it's justifiable.
Well, as the judge said, this is an evolving process, and we're all getting better at it as we go along. So we've only got about 5 minutes left, Eric, and I know we've got two topics left, but maybe you can just quickly maybe combine your Rule 45 and cost shifting topics, and spend a couple minutes there, and then we'll query our two panelists and then finish up.
Sounds good. Thanks, Skip. So with the Rule 45 subpoena, the way that proportionality really plays into this is when this is suggested by the Sedona principles is that parties need to be realistic about this stuff. You can't just send a Rule 45 subpoena to a third party that has nothing, that's not directly involved with the case and ask for every document under the sun. That's unfair to them. But sometimes that type of discovery is needed, and that's where cost shifting can play in. So if a recipient of a Rule 45 subpoena needs to sift through a huge amount of data to find useful documents to help resolve a case that they're not even involved in, it's a good situation for cost shifting, because maybe the party issuing the subpoena needs to bear the expense. And cost shifting can also factor in to proportionality, even when a Rule 45 subpoena is not actually involved. And so one recent case from 2020 was Lawson v. Spirit Aero Systems from the District of Kansas. And that in that case, the court warned this Lawson repeatedly. Spirit has already borne its fair share of expenses. And Lawson was just bullheadedly trying to get through this, despite using these technology-assisted review searches that were only getting a responsive rate of 3.3%. And so this is what I was talking about earlier with, searching for one needle in a haystack and getting terrible results. And so even the documents that were technically responsive were of marginal relevance anyway. So the court found that the ESI process became disproportionate to the needs of the case and shifted costs from the requester, or from the party receiving the requests over to the requester. So then we can have the panel discuss cost shifting and their experience with it.
Yeah, I'm actually going to break my questions up here. I'm going to ask the judge first. Judge, do you typically treat Rule 45 proportionality analysis differently, or treat a third party differently than you would a party because they're a third party?
To some extent. I mean, proportionality requires that you look, among other things, about whether there are less expensive, less invasive ways of getting the same thing. And certainly the Rule 45 case law that requires you to look at whether one of those ways may be from the opposing party rather than from the non-party. That's an important consideration. One of the things that I find challenging as a judge and as a magistrate judge responsible for managing the scheduling order is that if you wait until the end of discovery to get everything from the opposing party and then decide that you need to serve a subpoena, then that's when the parties are back to me asking for more time, because the non-party is saying, whoa, I just got this request. I can't turn it around in 2 weeks. Right. And you kind of get that. So I do encourage the parties to at least be planning their discovery and perhaps even serving the subpoenas, but with an open response date fairly early on, and to include the counsel for the opposing party in the meet and confers to see if among the three of them they can come up with a sensible path forward.
Well, that's good advice, and I think people don't always think about the timing of the Rule 45 versus the other discovery requests. So I think that is a good thing to think about. Sarah, I'm not even gonna. I know you deal with Rule 45 a lot, but I'm going to ask you a different question actually. And I know there was a case, I think it's called ADARE, that the court suggested one way to reduce costs, and in a proportionality discussion, is just have the producing party produce everything without doing a review, and then you can always claw documents back. Has the bank ever done that, or would you be comfortable doing it?
No.
Okay. Same way.
That's an easy answer. Nope.
Yeah.
No.
Yeah.
I mean, I know there are clawback rules and there's supposed to be protections, but once it's out, right? And so I've never encountered a situation where we've gotten comfortable with that.
Yeah. And Judge, have you bumped into that at all? Either ruling on it or dealing with disputes about it?
I haven't had to rule on a dispute like that. I agree with Sarah. I would not enter with an order like the one that was entered in ADARE. That being said, there is a continuum, and I don't think a party is entitled to insist on Cadillac review to find every single possible privilege document and then argue that that makes it disproportionate. So there's a place where you get to good enough, and you've got the protection of the clawback if something gets through.
Okay, very good. Well, let's go to the last slide. I think it's all the way to the end. One more. There we go. Practice pointers, action items. I'm not going to go through all these. It would really just be a summary of what we talked about. One thing I will just mention that I think is worth looking at. I mentioned the George Washington project on proportionality, and it really is, it's an attempt by a number of practitioners and judges to put together basically a heat map, a burden balance analysis that ultimately I think the hope is that parties and courts will use. And it's actually a grid where you measure a number of different factors that we've looked at with respect to proportionality. And it provides, I won't say a scientific, but it feels more scientific basis for making your proportionality arguments and for the court to issue to make a proportionality ruling. So I encourage you, go to the GWU, George Washington University website, and just look for their proportionality discussion and conference. And it's fascinating stuff, and hopefully we'll see that being used more in the future. So that's it. I'm going to ask just the judge and Sarah if they have any parting words of advice before we say goodbye to everyone. Judge?
I think my parting shot would be, don't forget about Rule 26G, which says that when you sign a set of discovery requests or you sign a set of discovery responses, you are telling the court that they comply with the rules and that they are not unreasonably burdensome or otherwise unreasonable. So the attorney can't just separate themselves from the client when it comes to that. They're making some representations.
Good advice. Thank you. And Sarah, any final thoughts?
Nothing too profound. I would say whether the case is big or small, be sure to work with your client very early on to understand where the data is and who the custodians are. Hopefully everyone is already doing that. That's our experience with Dorsey anyways, but still good advice.
Wonderful. Well, thank you both. And thank you, Eric, for a fantastic presentation. And thank everyone who attended today. We hope that this was enlightening and that both presentations help you sleep better at night. So with that, I say goodbye to everyone. See you next year.